Tell me right now how you afford a $200,000 car.
I don't have to explain my finances. I've committed no crime.
Then I'm assuming it's stolen.
You're on camera, and you're detaining a federal judge without cause.
Yeah? Prove it.
You're about to.
In the dimly lit underground parking garage of a premier shopping district in downtown Chicago, a police officer confronted me while I stood beside my luxury vehicle, immediately assuming the car couldn't possibly belong to a black man. What started as a simple trip to pick up a graduation gift for my son would escalate into a documented case of racial profiling that would cost the city over $15.5 million and force an entire precinct to reckon with its practices. Before I continue my story, I need you to do something. Drop a comment and tell me where you're reading this from. And please hit that follow button right now. This experience gets absolutely wild, and you are going to want to see how it ends. Officer Mark Henderson, 42 years old, had spent 12 years with the Chicago Police Department, most of them working the affluent Magnificent Mile district. His personnel file, which my lawyers would later uncover, showed a troubling trend that supervisors had consistently overlooked. In the past 3 years alone, he'd initiated 230 vehicle stops in parking garages and lots throughout his patrol area. 190 of those stops involved black or Hispanic drivers. 145 involved vehicles valued over $80,000. And of those 145 stops, only 7 resulted in any citation or arrest. A success rate so low, it suggested the stops had nothing to do with law enforcement. But the complaints against Henderson never seemed to stick. Victims would file reports describing aggressive questioning demands to explain how they could afford their vehicles and threats of arrest for refusing unlawful searches. The department would investigate. Henderson would claim he was just being thorough, and the complaints would be marked as unsubstantiated. The pattern continued unchecked until the evening he stopped the wrong person in the wrong place at the wrong time. The parking garage beneath the Water Tower Place was a concrete maze of luxury vehicles, designer shopping bags, and the quiet hum of engines echoing off low ceilings. Security cameras covered every angle, high-definition feeds recording 24 hours a day, backed up to secure servers that kept footage for 90 days. Every entrance, every parking space, every elevator had eyes on it. The garage was designed to be safe, to protect expensive cars and expensive purchases from theft. No one had considered it might need to protect people like me from being profiled by police. I am Justice Marcus Thorne. At the time, I was 50 years old. I was standing beside my Mercedes-Maybach S-Class, loading shopping bags into the trunk after purchasing a vintage watch for my son's 18th birthday. I was a federal appellate court judge, one of only a handful in the Seventh Circuit, with a reputation for meticulous legal analysis and absolutely zero tolerance for constitutional violations. I'd spent the day reviewing briefs in a complex civil rights case. Now, I just wanted to get home, wrap the gift, and surprise my son at dinner. I was arranging the bags carefully in the trunk, making sure the watch box wouldn't shift during the drive, when I noticed the patrol car in my peripheral vision. Not passing through, not patrolling, but stopped, angled, slightly positioned, right behind my Maybach. The officer inside was staring directly at me. My first thought was practical. Maybe there had been an incident in the garage, a theft report, a suspicious person call. I continued organizing my bags, hands visible, expecting the officer to either move along or approach with a legitimate question. What I didn't expect was what happened next. Officer Henderson stepped out of his patrol car with the confidence of someone who'd done this hundreds of times before. He walked directly toward me, his footsteps echoing in the concrete space. Each step was deliberate and heavy, not the cautious approach of an officer concerned about threats, assessing danger, or maintaining tactical awareness. This was the casual swagger of someone who'd already decided this stop was justified, someone who'd profiled me based on nothing more than the color of my skin and the value of my vehicle. He approached from the side, positioning himself between me and the open trunk. His presence was deliberately intimidating, close enough to invade my personal space, aggressive enough that shoppers nearby noticed the tension immediately. "Good evening, officer. Is everything all right?" I asked, my tone polite but direct, keeping my hands visible near the shopping bags. Henderson's eyes scanned me from head to toe, then moved to the shopping bags in the trunk, then to the Maybach itself. The quilted leather interior, visible through the open door, the shopping bag from a high-end jeweler, the pristine condition of the vehicle. Everything about the scene screamed wealth, and everything about the black man standing beside it, in Henderson's view, didn't match. License and registration. Now, the tone wasn't a request. It was a command delivered without explanation, without courtesy, without any acknowledgement that the person before him might be there legitimately, that I might have every right to load shopping bags into my own car without being interrogated, that I might deserve the same presumption of lawfulness that white drivers in expensive vehicles received without question. "May I ask why you're stopping me?" I kept my voice even professional. "I'm loading my vehicle. I haven't violated any laws." "I'll tell you why in a minute." License and registration. Henderson's hand moved to his belt, resting near his weapon. A gesture designed to remind me exactly who held power in this encounter. I slowly reached for my wallet in my back pocket, my movements deliberate and visible. "Officer, I'm cooperating fully, but I'd like to know the reason for this stop." Henderson barely glanced at the license when I handed it to him. "Where's the registration?" "It's in the glove box. I can retrieve it." "Do that, and keep your hands where I can see them." I opened the driver's door, leaned in to access the glove box, and retrieved the registration. I handed it to Henderson, along with my license. All my movements were slow and visible. Henderson barely glanced at the documents. Instead, he began walking around my Maybach, circling it slowly, running his hand along the paint, checking the rims, peering through the windows. His body camera recorded everything: the sleek lines of the expensive car, the judge standing calmly beside it, shopping bags visible in the trunk, and most importantly, the officer's own actions that would later be picked apart, frame by frame, in federal court. "This is a Mercedes-Maybach," Henderson said, returning to where I stood. "Goes for over $200,000 new. You want to tell me how you can afford that?" My expression didn't change, but internally, I recognized exactly what was happening. I'd presided over cases like this. I'd read depositions describing these exact questions. I knew the playbook. "I'm not required to explain my finances to you, officer. I've provided my license and registration. If there's a violation you're investigating, please tell me what it is." "The violation," Henderson said, stepping closer, "is that you look like someone who shouldn't be driving this car. So either you're going to explain where you got it, or I'm going to assume it's stolen." The words hung in the air, clear, documented, undeniable. The security cameras overhead captured the moment. Multiple angles showing the officer's aggressive posture, me standing calmly beside my vehicle, with shopping bags in the open trunk, and the confrontation building in a parking garage that should have been nothing more than a place to load purchases and leave. A woman walking to her car slowed down, sensing tension in the way people do when something feels wrong, even if they can't immediately articulate why. The body language, the aggressive posture, the way the officer positioned himself to intimidate. She pulled out her phone, not to make a call, but to record, understanding instinctively that documentation might matter. that whatever was unfolding might need witnesses, that silence was complicity. An elderly man, loading shopping bags into his trunk, stopped mid-motion, bags dangling from his hands, watching the confrontation develop. He'd lived through the civil rights movement. He'd seen this before. Different uniforms, different vehicles, but the same fundamental dynamic of power being misused, of bias being enforced, of someone being made to justify their existence in a space they had every right to occupy. More shoppers emerged from the elevator, drawn by the commotion, the raised voices, the unmistakable tension of a police encounter that had gone wrong. They formed a loose semicircle, maintaining distance but refusing to leave. Their presence created a buffer between unchecked authority and a man who'd done nothing wrong. The witnesses were accumulating. The documentation was building, multiple angles, multiple devices, multiple perspectives, all capturing the same fundamental truth. And Officer Henderson, so focused on the man beside the Maybach, so certain of his own righteousness, so accustomed to stops like this, going unchallenged, didn't notice or didn't care that his behavior was being preserved from a dozen different angles. He didn't realize that the traditional dynamic, where his word against the driver's word would prevail, was being disrupted by technology, solidarity, and the simple act of people refusing to look away. I made a decision. "Officer Henderson," I said, reading the nameplate on his uniform. "I'm going to tell you something important. I am a federal appellate court judge. My identification is in my wallet, which you currently have. What you're doing right now is racial profiling, and it is being recorded by multiple cameras." Henderson actually laughed, a short dismissive bark of sound that the body cam picked up perfectly. "Federal judge, right, that's what they all say." He looked down at the wallet still in his hand, the one I had given him with my license. He opened it, more thoroughly now, pulling out cards and looking at each one with exaggerated skepticism. He found the judicial ID, the federal seal prominent, my photograph and credentials clearly printed. He stared at it for several seconds, his expression shifting from mockery to confusion to something approaching concern. But instead of backing down, Henderson doubled down. "This could be fake," he said, holding the ID up, as if examining it for forgery. "We've had people with fake credentials before. Stay right here while I verify this." My patience was thinning, but my composure remained intact. "Officer, you can verify my credentials through any federal database in about 30 seconds. My court identification number is on that card. You can call the courthouse. You can contact court security. What you cannot do is continue to detain me without cause." "I've got cause," Henderson snapped. "You're standing next to an expensive car you probably can't afford in a high-crime area, acting suspicious." Every word was documented. Every word was wrong. The shopping center was in one of the safest neighborhoods in Chicago. I hadn't done anything suspicious. I'd been loading shopping bags into my own car. The assumption that I couldn't afford the vehicle was based on nothing but bias. The woman who'd started recording moved closer. "Excuse me, officer," she called out. "He hasn't done anything wrong. Why are you harassing him?" Henderson whipped around. "Mom, step back. This is police business." "This is a public garage," she replied, her phone steady, "and I have every right to record." Officer Henderson returned his attention to me, frustration now clearly visible. "Put your hands behind your back." "On what charge?" I asked. "Obstruction," Henderson said. My response was immediate and precise. "I am not obstructing. I am standing beside my vehicle, which I own, after lawfully loading shopping bags in a public garage. I have provided identification and registration. I have answered your questions. I have committed no crime, and I am not required to submit to arrest without probable cause." The legal precision of my response seemed to irritate Henderson more than silence would have. He keyed his radio. Dispatch Unit 47. I need backup at Water Tower Parking Garage, Level P2. Uncooperative subject, possibly stolen vehicle. The false report would later become a key element of my lawsuit. There was no stolen vehicle. The Maybach's registration was current, verified, with my name clearly listed. The VIN matched. The insurance was valid. Every document was in order. But Henderson needed justification for the escalation. So he created one, broadcasting it over the radio, where it would be recorded, time-stamped, and preserved. I stood perfectly still, hands visible at my sides, watching as more shoppers stopped to observe. The crowd was growing, 5 people now, 7-10. Phones raised, recording from different angles, ensuring that no matter what happened next, the truth would be documented. Within 3 minutes, a second patrol car arrived, followed quickly by a third. Officers emerged, converging on the scene, and the underground garage that had been quiet moments before now felt like a major police operation. All for one black man, standing calmly beside his own car, with shopping bags in the trunk. Officer Maria Rodriguez, younger and less experienced than Henderson, approached first. "What's going on?" Henderson gestured at me. "Driver won't cooperate. Claims to be a federal judge. Vehicle might be stolen. Credentials look fake." Rodriguez glanced at the Maybach, then at me, standing calmly beside it, then at the growing crowd of witnesses. Her expression suggested uncertainty. "Sir," she addressed me, "can you provide identification?" "I already did," I replied calmly. "Officer Henderson has my license, registration, and judicial ID. All legitimate, all verifiable. I'm being detained without cause." Rodriguez looked at Henderson. "Can I see the ID?" Henderson handed it over reluctantly. Rodriguez examined it, pulled out her phone, and began typing. The federal court website, the roster of judges, the official listing with photographs and credentials. It took her less than 60 seconds to verify what Henderson had refused to accept. Her face went pale. "Mark," she said quietly, "this is real. He's actually a federal judge." The words carried through the garage. The witnesses heard. The woman recording zoomed in on Henderson's face as the realization hit him. The third officer, Sergeant David Miller, stepped forward. He was older, early 50s, with the bearing of someone who'd seen too many situations go wrong. "What's the verification?" Rodriguez turned her phone around, showing the official court website with my photograph and biography. Federal appellate court judge, appointed 6 years ago, currently sitting on the 7th Circuit. Miller's jaw tightened. He looked at Henderson, then at the crowd, then at the multiple phones recording. He understood immediately that this wasn't just a bad stop. This was a catastrophe fully documented. Impossible to deny. "Your Honor," Miller addressed me with the proper title. "I apologize for this encounter. You're free to go. We'll be reviewing this incident internally." I didn't move toward my car door. Instead, I spoke clearly, ensuring the body cameras captured every word. "Sergeant, this wasn't a misunderstanding. This was racial profiling. Officer Henderson stopped me because he assumed I couldn't legitimately own this vehicle. He fabricated a stolen vehicle report. He threatened arrest without cause. He violated multiple constitutional rights, and all of it is documented." Miller nodded slowly. "I understand, Your Honor. I strongly recommend you file a formal complaint." "I will be doing more than that," I replied. "Now, if you'll move your vehicles, I'm going home." The patrol cars backed away. The officers retreated, though Henderson's face had gone from red to ashen as the full weight of his mistake settled over him. I closed the trunk, walked around to the driver's side, and got into my Maybach. The engine purred to life, and I drove slowly toward the garage exit. Behind me, the witnesses remained, comparing videos, discussing what they'd seen, already uploading footage to social media. The woman who'd first started recording posted her video with a caption, "Federal judge racially profiled in Chicago parking garage. Officer assumed he stole the car. Full video, no edits." Within an hour, it had 50,000 views. By morning, every major news outlet in Illinois was covering the story. Federal judge profiled while shopping. The headlines read, "Chicago police officer accused of racial bias in documented encounter." Video shows Justice Thorne questioned about vehicle ownership. The story had everything media organizations looked for: clear video evidence, a sympathetic victim with unimpeachable credentials, an officer with a documented history, and the larger questions about systemic bias that resonated far beyond one parking garage. The footage went viral in waves. First, the woman's recording raw and unedited, her voice audible as she called out the officer's behavior. Then the bodycam video released after a public records request, which showed everything from Henderson's perspective and somehow made his actions look worse because it captured his own words, his own choices, with no filter or interpretation. News broadcasts played the footage in segments, pausing at key moments. Here where Henderson refuses to verify credentials. Here where he fabricates the stolen vehicle report. Here where Rodriguez confirms, "I am actually a judge," and Henderson's face registers the realization. Legal analysts dissected each decision, explaining the constitutional violations in language accessible to viewers who might not understand probable cause or reasonable suspicion, but understood unfairness when they saw it. Social media exploded with reactions. My name, Justice Thorne, trended nationally within 36 hours. Legal professionals shared the videos with commentary about the Fourth Amendment violations. Civil rights advocates used it as an example of racial profiling that even skeptics couldn't dismiss because my credentials were so clear. Community organizers pointed out that my status shouldn't matter, that constitutional rights applied to everyone, but the case proved how bias operated even against people with significant social and professional standing. Civil rights organizations issued statements within 24 hours. The NAACP called for Henderson's termination. The ACLU announced they were monitoring the situation. Local activists organized protests outside the police precinct, demanding accountability for what they called a pattern of discriminatory enforcement that had gone unchecked for too long. Other victims began contacting attorneys, sharing their own experiences with Officer Henderson. A professor from the University of Chicago described being stopped in the same parking garage, questioned about his Tesla, and told he should be driving something more appropriate for his income level. A surgeon recounted being detained for 45 minutes while Henderson ran his credentials multiple times, certain there must be outstanding warrants. A software engineer described being searched without consent after refusing to explain how he afforded his Range Rover. Each story followed the same pattern: expensive car, black driver, immediate suspicion escalation without cause, and documentation that went nowhere because the department had chosen not to act on complaints against an officer who generated impressive stop statistics, even if those stops rarely resulted in actual enforcement. The Chicago Police Department launched an internal investigation, but the public pressure made clear that internal review wouldn't be sufficient. The mayors called for an independent investigation. The city council demanded answers. Community leaders organized town halls, where residents shared experiences of being profiled, creating a chorus of voices that could no longer be ignored. 10 days after the parking garage encounter, I filed a federal civil rights lawsuit. The complaint was 52 pages long, meticulously detailed, supported by multiple videos, body camera footage, witness statements, and my own testimony. The named defendants included Officer Henderson, Sergeant Miller, for failing to properly supervise the precinct commander, for ignoring complaint patterns, and the city itself for maintaining policies that allowed discriminatory policing to continue. The claims included unlawful detention, racial profiling, violation of Fourth Amendment rights, violation of 14th Amendment rights, intentional infliction of emotional distress, and civil conspiracy to deprive constitutional rights. The damages sought totaled $15.5 million. But the lawsuit was about more than money. Discovery requests demanded 5 years of Henderson's stop records, personnel files for all officers in the precinct, complaint records, training materials, and internal communications about racial bias. The case was building towards something larger, an examination of whether the department had created a culture that encouraged or at least tolerated discriminatory enforcement. The data that emerged during discovery was damning. Henderson had stopped black drivers at rates 380% higher than white drivers in the same patrol area. His vehicle searches of black drivers were 520% higher. His use of backup for routine stops involving black motorists was 290% higher, and his citation rate was 73% lower than the department average, suggesting most stops had no legitimate law enforcement purpose. More troubling was what the internal communications revealed. Supervisors had been aware of Henderson's disproportionate stop patterns for years. Early intervention systems had flagged him repeatedly. Complaints had piled up, but each time his sergeant had defended him, claiming he was just proactive, just thorough, just were trying to keep the community safe. The protective instinct within the department had shielded Henderson from consequences, even as evidence mounted that his policing was driven by bias rather than law. The pattern wasn't just about numbers, it was about people whose daily lives had been interrupted by bias wearing a badge. It was about professionals who'd achieved success being treated like criminals because their success didn't match the officer's expectations. It was about dignity stripped away in parking garages on street corners in front of shopping centers, documented only by victims' memories and occasionally by phone cameras that caught fragments of longer encounters. One victim, a high school principal, described being stopped in front of his own school while arriving for work. Students watched as Henderson questioned him about his Audi, demanded to search it, and threatened arrest when the principal asked for a supervisor. The humiliation lasted 20 minutes, ending only when the school resource officer recognized the principal and intervened. That incident had been reported to the department. The complaint had been marked as resolved with verbal counseling. No record existed of that counseling ever occurring. The city's attorneys reviewed the evidence and came to a stark conclusion. The videos were indefensible. The body cam footage showed clear racial profiling. The false stolen vehicle report was documented on radio recordings. My credibility was unimpeachable. Fighting this case at trial would be disastrous, both legally and politically. A federal judge testifying about being profiled by city police would generate national headlines and set precedents the city didn't want established. 4 months after the parking garage encounter settlement negotiations began, my attorneys demanded not just compensation, but structural reforms. The city needed to admit wrongdoing. Henderson needed to be terminated. Training needed to be overhauled. Oversight mechanisms needed to be strengthened. The settlement couldn't just resolve one case, it needed to address systemic problems. The final settlement reached after 6 weeks of negotiation was comprehensive. $15.5 million paid to me. A formal public apology from the mayor and police superintendent. Officer Henderson was terminated with his certification revoked, ensuring he could never work in law enforcement again. Sergeant Miller was demoted and reassigned to a position without supervisory authority for failing to properly manage his officers. But the most significant provisions were the reforms. The department would implement mandatory implicit bias training for all officers 60 hours within the first year. Stop data would be analyzed quarterly for evidence of racial disparities, with results published publicly. An independent monitor would audit the department for 3 years. Community oversight boards would review all complaints involving allegations of discrimination. Body camera footage of every stop would be randomly audited monthly. Officers showing problematic patterns would be immediately placed under enhanced supervision. The reforms extended to hiring and promotion. The department would recruit more officers from diverse backgrounds. Promotion criteria would include evaluations of bias awareness and community trust. Performance reviews would consider not just stop numbers, but the legitimacy and outcomes of those stops. The emphasis would shift from volume to quality, from activity to actual public safety. Training academies redesigned their curricula. My case became required study, along with dozens of others. Recruits watched the parking garage footage and were asked to identify every decision point where the encounter could have gone differently. They role-played scenarios where they had to intervene when a colleague exhibited bias. They heard from community members about the impact of being profiled, the fear it created, the trust it destroyed. The garage itself became an unlikely teaching tool. The management at Water Tower Place installed a memorial plaque near where the encounter occurred with text reading, "On this site, an unjust stop led to meaningful change. May we learn from this moment to build a more equitable community." Tour groups from the police academy visited, standing in the spot where I had been detained, discussing what the case meant for their approach to policing. Some officers resisted the changes. A vocal minority claimed the reforms would prevent them from doing their jobs effectively. Several retired or transferred to other departments rather than adapt. But most recognized that my case had exposed problems they'd known existed but felt powerless to address. The reforms gave them language and tools to challenge bias when they saw it, permission to prioritize quality over quantity, and protection from retaliation when they spoke up about problematic behavior. The department's stop data showed dramatic shifts within the first year. Racial disparities in stops decreased by 47%. Searches without probable cause dropped by 61%. Complaints about officer bias fell by 58%. Use of force incidents declined by 34%. The changes weren't perfect and problems persisted, but the trajectory was clear. Accountability created pressure for better behavior. Community trust began to rebuild slowly. Officers attended neighborhood meetings not to defend the department, but to listen. Youth programs connected police with young people in contexts beyond enforcement. Community policing initiatives emphasized relationships over arrests. The work was slow, often frustrating, but necessary. I returned to my routine, presiding over cases with the same careful attention I'd always brought to the bench. I gave no interviews. I didn't write an opinion piece. I released a single statement when the settlement was finalized. This case was never about my position as a judge. It was about my rights as a citizen. Every person, regardless of race or status, deserves to be treated with dignity and within the bounds of constitutional law. Officer Henderson's actions weren't an isolated mistake. They were part of a pattern the department had tolerated for too long. I hope this settlement creates lasting change, not just policies on paper, but actual transformation in how officers see and serve their communities. The statement was measured precise, the voice of someone who understood that legal victories didn't automatically translate to cultural change, that settlements could mandate reform, but implementation required sustained effort and genuine commitment. Months after the settlement, I returned to the Water Tower garage to shop for another family occasion. I parked in the same garage, on the same level, not far from where the encounter had occurred. I walked past the memorial plaque, pausing to read the words I'd seen before, but which carried different weight now. A patrol car was visible 3 rows away. The officer inside was completing paperwork. The officer looked up as I began loading shopping bags into my trunk, made eye contact, and nodded respectfully. No approach, no questions, no assumption that someone needed to explain their presence. Just 2 people sharing space in a parking garage. One shopping, one working, neither seeing the other as a problem requiring intervention. I closed my trunk, got into my Maybach, and drove toward the exit, thinking about how much had changed because one officer had acted on bias, because one judge had refused to accept being treated as less than equal, because multiple cameras had documented everything so thoroughly that denial became impossible. The cameras in that garage still record constantly high-definition footage backed up to secure servers. The memory remains preserved in video files and court records, in training materials and conversations that happen when officers gather to discuss what they've learned from the Thorne case. And every officer who patrols Chicago's affluent neighborhoods knows the story of what happened when assumptions about who belongs where met a federal judge who understood exactly what his rights were and had the resources to fight for them, effectively creating change that extended far beyond one parking garage, one settlement, one case. Because sometimes the most important courtroom isn't made of marble and mahogany. Sometimes it's concrete and fluorescent lights, security cameras, and cell phone videos. A space where justice happened not because of the system, but in spite of it. Where documentation defeated denial. Where witnesses refused to look away. Where one person's refusal to accept being treated as less than human sparked reforms that would protect thousands of others who would never know his name but would benefit from his courage. If you believe that profiling should always be challenged, that documentation saves lives, that accountability isn't optional, and that change happens when people refuse to accept being treated as less than human, then hit that follow button. These stories matter. These lessons resonate. And these fights continue, requiring vigilance, courage, and the determination to build systems that serve everyone equally, regardless of what they look like, or what they drive, or whether they match someone's assumptions about who belongs in an expensive car. This narrative is a retelling based on a true story. All names, characters, Justice Marcus Thorne, Officer Mark Henderson, locations, and specific incidents have been changed for dramatic and educational purposes. The intent of this story is to illustrate the real-world impact of racial profiling, the importance of knowing one's constitutional rights, specifically regarding the Fourth Amendment and unlawful detention, and the power of documentation and community witness in holding institutions accountable. It serves as a reminder that systemic change often requires both individual courage and collective action.